Thank you, Mr. Chairman. I am privileged to serve as the ranking member of this committee with a chairman who can spin all sorts of wonderful yarns, and sometimes they actually bear some resemblance to the truth. I won't opine as to whether or not the one that you just heard did or not, but I will say and echo his comments, and that is that this is an important issue, and so I want to thank the witnesses for joining us today on and to present your experience, the information that you have. And Mr. Gross, we look forward to your testimony. The issue before us today, as I mentioned, is truly an important one, and to put it mildly, it's more than a little complicated, especially for those of us who aren't lawyers. As a physician, the first tenet of medicine is first do no harm, and that's not oftentimes followed here in Washington. So I think one of the concerns that we have, is to make certain that we don't do harm, that we don't march down a road that would result in significant unintended consequences, especially when an issue is so complicated and touching on a matter as important as our civil rights laws. A close and thorough examination is certainly warranted. The bill before us comes in response to last year's Supreme Court decision in Gross v. FBL Financial Services. In Gross, the court held that as a matter of the plain language of the statute, a certain standard contained in Title VII of the Civil Rights Act was not applicable to plaintiffs bringing claims of age discrimination under a different statute, the Age Discrimination in Employment Act. Now, I think one can argue whether the Gross case was properly decided by the Supreme Court. It was a narrowly divided decision, as we all know, and included a very strong dissent. Good minds can and will disagree over whether or not the majority's holding was the correct one. What's beyond dispute, however, is that despite its title, the Protecting Older Workers Against Discrimination, this legislative remedy goes far beyond simply amending the Age Discrimination in Employment Act and reversing the Gross decision. Make no mistake, this bill is not simply a, quote, restoration, unquote, of where the law stood the day before the Gross case was decided. Instead, the bill before us purports to apply to a vast and undefined range of laws, federal and possibly state, which might be characterized as protecting against employment discrimination, retaliation, or participation in workplace investigations. We are deeply concerned that the vague and expansive reach of this law will undo years of settled case law and practice under statutes wholly unrelated to the Gross case, or to the protection of older workers. Indeed, in too many ways, this legislation makes broad, substantive changes to our nation's civil rights laws under the facade of narrowly reversing a single Supreme Court case. With that in mind, I'm truly interested in hearing from our witnesses what the practical effects of the Gross decision have been and what the practical application of the bill before us might be. Is the bill properly drafted? Should it be more narrowly targeted? Unintended consequences, what are we overlooking given the broad scope of the bill? And at the end of the day, will the bill truly protect workers from discrimination or simply be another boon for the trial lawyers? I want to thank the chairman for organizing this hearing, and I look forward to the testimony of the witnesses.